Hello and welcome to this discussion with Creative First. We have with us today veterans and industry experts to discuss the value of intellectual property in the creative industry. So without much ado, let me invite our esteemed speakers. Our first speaker, Anjum Rajabali, is a veteran Indian screenwriter, actor, teacher, and senior member of the Screenwriters Association. He has written films like Dhruv, Gulam, The Legend of Bhagat Singh, and Rajniti. Anjum has also acted in many films such as Veere the Wedding, Turning 30, and Gajini. As an academician, he has founded screenwriting and screenplay writing courses at the FTII and the Whistling Woods Film Institute. He regularly conducts workshops, seminars, and conferences on screenwriting. Anjum, welcome to the session.
Thank you very much, Loita.
Our second speaker, Jamshed Mistry, is an experienced counsel and founder of the International Legal Alliance, which is a virtual global network of lawyers. He has a demonstrated history of working in the law practice industry and skilled in various types of litigation, international law, media and entertainment law, medical, legal, social, and public interest causes. He is also a member of the Bar Association, the Intellectual Property Rights Practitioners Association, Maximum Lawyer Group, and associate member of the Canadian Bar Association. He is an advisory member of the South Asian Fashion Week and the Vancouver International South Asian Film Festival. So I see a lot of synergies in this discussion. And Anjum, let me first start with you. Tell us about your illustrious journey as a screenwriter and how intellectual property is important for every screenwriter.
Well, thank you very much. I mean, that was a very kind word, but it's inappropriate. It hasn't been an illustrious journey. It's been a journey of struggle. It's been a journey of discovery with all kinds of mistakes and learnings put together. My entry into the field of screenwriting wasn't really a planned one. I mean, I never came to the city to become a screenwriter. I mean, it happened purely by accident. I was pursuing some other field, which didn't work out. And as a result of which, I had a job, I was working okay, earning okay, but there was a creative emptiness. And by accident, I stumbled into screenwriting and enjoyed it. So became a serious hobby, and then it proceeded and then became professional eventually. I haven't done that much work, frankly speaking. I mean, in terms of the films which have come out, because most writers from my generation have been far, far more prolific. So in the last 29 odd years, I've had 11 releases until now. It's been interesting and it's been a discovery at various levels. I'm not going to touch upon the creative part of it, but I will touch upon the professional and the legal aspect of my own struggles. See, for the longest period of time historically, by law as well as by norm in the film industry, everything that the writer wrote from the moment that she put her pen to paper was owned by the producer. Even if a single rupee was exchanged, it belonged entirely to the producer. The producer was at full liberty to change what he wanted to change, to be able to fire the writer, engage somebody else. There were frequent stories when I heard, and too many stories of installments, in fact, the later installments of the understanding not being paid at all. And generally, I was told that post-release, you can forget it in case there is some particular installment which has been kept waiting. So effectively, the system was that you were entirely dependent on the fancies without really there being any regulation of the relationship between the writer and the producer, with certain mutual accountability norms laid down. And as a result of which, nor was there any protection in case the writer got treated arbitrarily. It is into this field, into this culture that I had joined. And it began to bug me that if this is meant to be a professional exchange, I'm not your employee. So I'm bringing something to the table. I'm accountable to your timelines. I'm accountable to a certain quality that I have promised you. I'm also accountable to rewriting as many times as is necessary to be able to achieve some degree of satisfaction from the director and the producer. But I don't find any reverse accountability coming from there. So even before I have been paid my full amount, which at that time used to be called price, even before that happens, you've already purchased my goods. So you're not even obliged to be held accountable to pay me. There was no forum where you could go for recourse. The Film Writers Association was there, but unfortunately, it wasn't terribly active or proactive and didn't really function like a union that you could turn to. Courts were too cumbersome and too expensive. The copyright law was effectively against you because it did say the pre-2012 amendment of Indian Copyright Act 1987, it in fact said that even without a contract, as long as a single rupee was exchanged, the entire rights would transfer to the producer, to the purchaser. So this was the situation in which we stepped in. There were no contracts, Lavita, because there was supposed to be an understanding, which I think we should touch upon as we move forward about how things are changing. But the point I'm making very sharply and very emphatically is that the situation really left the writer bereft of even a modicum of protection here. And it wasn't a happy place to be in. You were constantly vulnerable. And intellectual property becomes important because even then, the world over, there was the concept of intellectual property and copyright was an accepted norm in most countries. I mean, America, of course, being the foremost of those. And because it was your property, you generated it, you created it, so therefore you had the right to decide where it would go. And before the agreement was made, if you wanted to place certain conditions of what would be done to it and how that would be done, you were at liberty to do that. And if that the agreement doesn't work out to your satisfaction, you can take this elsewhere. This norm wasn't there. So writers, because of this feudal nature of the system, were constantly made to feel dependent on the largest of the producer. Kaam mil gaya. And this, even writers had introjected and internalized that particular attitude. So the fight for intellectual property has been a long drawn out one, but perhaps we can touch upon it at some length as the discussion proceeds. But I'm merely telling you this is what it was in the early 90s.
Anjum, to your earlier point where you said that probably you never thought of becoming a writer, immediately when you got exposed to this industry. So from that perspective, to all the creative people out there, do you think there's enough awareness about intellectual property rights in the industry?
Actually speaking, the situation has galloped, I would say. Are people adequately aware of this? Are enough writers aware of this? Not really. They still don't understand the contours of that because it appears like, oh, this is some legal thing, and that I don't know how to read a contract, so I won't understand what the law is. But what they have become conscious of is this basic notion that this, if I have written this on spec, this is mine. Okay, and when I give it, I am in a position to negotiate, to bargain, and to have my freedom if I choose to give it or not choose to give it. That there is an economic pressure that our writers decently paid such that they can exercise this leverage across the board, not necessarily, because they live off this. Writers are underpaid, as is pretty well known. So as a result of which, it sort of keeps them in a vulnerable position where they need to continue to earn to be able to manage their home. Unlike, say, in the West, take the case of America, where it is spectacularly different. I mean, you write one film which has some medium level success, you're more or less okay for the rest of your life. I'm sorry to say this, because through residuals and various other spin-offs which come to you, you're fairly well taken care of.
Can you elaborate on that for our audience?
Yes. See, in India, because there is no collective bargaining regulation which has happened between the writers and the producers. So, therefore, each individual writer has to negotiate and bargain for his or her fees, credit, and various other rights individually. Now, here the problem is that the level of bargaining power is grossly unequal because the producer has the money, he is powerful, he has access to other writers should he want to throw that money around, whereas writer is not in a position to really bargain, doesn't feel that he has the bargaining power. So this inequality puts the writer at a at a low end here. And if the producer chooses to exploit the writer's desperation, as they generally do, then the fees for a new writer are abysmal, absolutely abysmal. Okay. Then the credit, which is the other thing that the writer actually works for. There are two things most important to his money, so that his home can be run. And number two is the credit, because on the credit depends upon the future of his career. Because when people see your name, they know that okay, this is a nice film you've written. That okay, call this writer. But if your name doesn't feature there, people don't know. Now there is a clause in the contract which goes almost across the board, which says that the final credit will be on the discretion of the producer. So in which case, what you're doing is that the writer's work, which should be acknowledged, this is show business. I mean, you need to depend on that, which should be acknowledged, is not acknowledged. Now, this can be rectified if there are certain standard norms for the contract. That this contract should definitely have these clauses, and these should be the basic safety protection that each writer should get out of that. And this is the accountability that he has towards the producer. So it becomes a contract based on mutuality and fairness. Individually, the producer, believe you me, is not interested in mutuality, is not interested in fairness, because right now he believes that he controls the entire bargaining leverage. So the only way this can be rectified is if the union, on behalf of the entire writing community, were to get into a collective bargaining agreement with the producer or the producers council, then in which case some kind of regulation can take place. And this is why Hollywood flourishes. You find some really high quality writing emerging from Hollywood, not just in cinema, but also in television, and now especially in the web space. I mean, in digital shows, OTT shows. But that's also because the writer has enough incentive, enough protection to be able to give his all to that one particular project, whether it takes 2 years or 3 years, to ensure that top quality work comes out there. Here, the large scale insecurity doesn't permit the writer to do that. So the rectifying can only be at this level. Now, take another example, since you mentioned intellectual property. Through a lot of hard work and a lot of lobbying, finally, the writers got convinced the government, and which was fair also at that time, the government was looking at it in any case, to amend the existing Copyright Act. And various rights were included for the writers, that without a contract, you cannot hand over your property, etc. Now, the thing here is that to implement that, you need a copyright society. Okay. The copyright society needs to get registered. Now, the government hasn't registered it yet, even though the application has been lying there for a while. All along, when we were putting it together, the formulating the basic framework of a copyright society, we needed the cooperation of the producers, because the law says that it will be jointly controlled by the producers and the writers. And the producers have been deadly opposed to this, even though it is the law. So every time our copyright society application has gone there, the producers have worked against it. So the point is that if you do not believe that you should come to the table and negotiate to ensure a mutual partnership, then in which case there is just large-scale bitterness and angst amongst the writers. And then when we complain that the quality of writing, still doesn't measure up. International audiences and film communities don't take us very seriously, primarily because the quality of our script. Well, you look at the condition of the writers in here. So it is actually by taking this position, according to me, the producing community is working against itself, and it's working against the future of cinema. If the writer doesn't do his job well, Lohita, the others don't have a job. It's dependent on the script. This is where you should be investing. So before this becomes a rant, I just want to sum up by saying that it is important that some kind of corrective measures have to happen in the position of writers here, as has already happened decades ago in America, where there is a collective bargaining agreement, and all these issues are jointly decided between the Writers Guild of America and these individual producers, broadcasters, and platforms. There are 722 signatories to that minimum basic agreement, where all these 722 companies have agreed that they will follow these norms and fulfill these requirements that the writers union has presented, and this is what regulates the relationship.
Right. Moving on, Jamshed, based on what Anjum said, I think he highlighted various aspects where probably there can be improvements with respect to IP, mechanisms like collective bargaining, talking about remuneration. But from a very simplistic point of view, could you please enlighten us on what are the steps that every writer should take to protect their IP? And from a contractual perspective, right from the time they put, their pen to paper.
So, at least as far as India is concerned, and I'll stick to that, the important aspect, I mean, there are, first and foremost, as Anjum very rightly said, I think it's very important that writers, just as, for example, I mean, I give the reverse. I mean, as an entertainment lawyer, I should know what example of Jimmy Jib is. Otherwise, if I go and a client comes to me and he says, this is what has happened on a set, I should know. Similarly, I think it's very important that the writer community, and I completely agree with Anjum on one aspect, that the writer is the sort of the cradle of the production. So he definitely should know his rights. And what are his rights? His rights are basically, his work, what he's able to creatively produce, and that then when it's sort of you're able to put it down in writing, then he becomes what is called the author. And thankfully, with the amendment in the law, that first authorship today is very, very important. The first authorship remains always with the writer. And I think that is a huge change as we moved, to the French system of, the copyright law. So it has given this protection to the writer. So I think that is one major aspect. The second, let me, before I come to the contracts, I think, and I'll give you a very good example with a matter in court a while ago, and I was appearing for a writer, and what happened was that he suddenly discovered that his whatever he had written, I think first 10 episodes were on television, and there was nothing that he could do about it. And we went to court. Yes, sometimes court is a cumbersome process, but sometimes courts are also very quick in appreciating this. And I was asked by the judge. He said, well, has it been referred to the Writers Association? I said yes, but I said they don't have the statutory powers that Anjum was referring to. In the US, the Writers Guild of America has statutory powers. If they say pen down means pen down, finish, industry stops. Now that kind of collective bargaining perhaps is something that really needs to, and he's right. It is on equal footing, and that therefore it gives a balance in the way things are. So I think we must please always remember, I always say this, we are a global industry, whether we like it or not. Okay, so whatever we do in India is now goes with the OTT and everything goes out instantly. So I think these norms should have been, the corrective measure should be that we must move immediately to a system where we can choose the best of the best and have our own systems in place. And definitely we must have some of the features that the Writers Guild has. So yes. So what is what can a writer do? What can he protect? Well, what he writes is his everything, and I think that needs to be captured. That needs to be at every stage. I mean, whether it is a synopsis, whether it is slightly larger sort of screenplay, or whether it is the final script, he can register his the copyright at all these three stages, and there's absolutely nothing wrong with that. And it can now, the great thing is today everything is online. So you make the application, you get the diary number very quickly. And the other interesting thing is, based on the minute you get your diary number, you can actually sue. Okay, that is again something that writers are not aware of. So that if, for example, somebody takes away or fraudulently or otherwise your script under the guise that, oh, give it to me, I'll take a read, and then, I mean, that's what has happened in so many cases. And Anjum is aware of these type of cases that go to the court. So
But where do these registrations need to happen?
at the very simple, at the Copyright Office we have
Right.
and it is online and it
Right.
is available. So that's the other great thing. I mean, the US Copyright Office is available for a worldwide registration if you want in the US, but today you can register it in India. You have the Berne Convention and several other conventions which gives you protection not only in India but other countries who are signatories. So India is a signatory to the Berne Convention. Therefore, you get automatic protection over there as well.
And when you say protection, just sorry to interject, but just hypothetically, while we are on that point, so if I make a script here, it's registered here, I'm protected, and say it goes to an Asia Pacific country where it gets adapted in a local language because the local industry is really big there, then how do I ensure that doesn't happen?
Now, the adaptation. So this is, of course, now we are getting into. So typically, what happens is you go to let us assume that there is a producer who has decided to produce it in, say, the language, which is, for example, Hindi. So you go ahead, you hand over the script, you enter into a contract with him. What the contract should say, etc., we'll come to later. But essentially, thereafter, once you are both the producer and you are bound under the contract, you then, I mean, and this is, I presume, is an original script. So after that, the process of the making of the film or the television or the episode, whatever it is, takes place. And also, please remember the copyright in the final film belongs to the producer. Okay, so he is also involved in this process. So when there is a sort of cheating or taking away of a copyright copyright infringement, say in another country, say by adaptation of rights, interestingly, not only your copyright as a writer is violated, even the producer's copyright is violated. That is sometimes people tend to forget. So it's a combination. So it's not only your sort of problem. Yes. Now the other important thing is, if, for example, and now adaptation rights is another chapter by itself. How you can hand over your rights through adaptation in a process what is called licensing. So that process, so nobody can use what you have unless you license it out to anyone in the world. That is very clear. Now, that license fee, again, it's subject to negotiation, it's subject to so many different things. But if you can prove in a court of law that somebody has used, and substantially, the interesting thing is that in a court of law, it says what an ordinary person view on the subject is. It's very interesting. So if it's like asking, say, somebody from the street to say, hey, watch this particular episode or watch this part of the movie, and now please watch the other part of the movie. And he says, yeah, I think this is absolutely similar. So this is the standard that we have been following so far. I think, over a period of time, this also needs a little bit of revision. Yes, now fortunately, the Screenwriters Association has a committee that actually can evaluate, two scripts and look into it, which is a very, very positive, and that has also been appreciated by, the High Court in certain cases. So on the second one question was on how important is registration. I think registration is important because it is when you register, copyright is then in your favor, not only for yourself, but what it is called in rem. It is in favor of you as far as the world at large is concerned. So that is why registration is very, very important. And the certificate that you get is actually your document of ownership of the script or
When
your
is the
work.
right time to register?
According to me, you can register the minute I think you should do a good amount of work and then register, because otherwise you shouldn't be sort of registration 2 and 3 pages. But you may have a synopsis, for example, okay, which is very important when you go to say a producer when it's an original work and you're trying to because it's the idea that's really important and what goes into it. So it might have a title, it might contain certain a description of what you're planning to do. That also can be registered. Very interesting.
Right. Anjum, Jamshed just mentioned that there is a mechanism in the Screenwriters Association to vet 2 scripts. Could you take us through that?
Yeah, certainly. See, the Screenwriters Association also accepts registration of material. And to also answer your question very specifically, see at which stage to register, a script goes through various stages. Right? From the idea, you work out a story. Story moves on, maybe forms a beat sheet, which is what in Bombay is called the screenplay, and then eventually it goes to the script. Now, the thing is that at any stage when you complete that stage, that means the first full draft of a story is written, whether it's a 1-page story or whether it's a 20-page story, then I think it is the time to register it. What Jamshed was saying, that you started writing a story, you've written a couple of pages and you said, let me register this. That would be rather counterproductive because it's an incomplete piece of work. So ideally, you should register a complete piece of work at whichever stage it is. Now, Screenwriters Association also allows people to register their work with them. Now, what does it say? Number one, it says that if you registered your work, it means that prima facie authorship belongs to you, which means until it is challenged and conclusively proved that it is either yours or somebody else's. Supposing I have taken Jamshed's work and registered it in my name. Jamshed's not to know. He's not going to check the thing every day. And moreover, we don't put out lists. So later, only if Jamshed becomes aware of it, and then now he has to, for example, present his document saying that Anjum registered it on the 11th of January 2019. My work was registered, in fact, in 2018. So now it becomes obligatory for me to prove as to how is it that my work predates him. So it becomes corroborative evidence, okay, which can be used in a case of whatever adjudication or in the case of mediation to figure out who is it that actually becomes the author of this. Number two, The Film Writers Association, which the Screenwriters Association, has a unit called the Dispute Settlement Committee, the DSC. What the DSC does is that if Jamshed believes that perhaps his work has been plagiarized by me, so he is, as a member, he can put in a complaint. Those people look at the complaint. If there is a prima facie case there, because a lot of people watch a trailer and say, oh, this looks like mine. So there might just be a very generic similarity or a conceptual similarity, in which case it doesn't really make for case of plagiarism or infringement. But if there is a prima facie case, because we have a full-time legal officer, qualified IP legal officer lawyer working there, she examines it, and if there is indeed merit in that, it's passed on to the Dispute Settlement Committee, which is full of experts. Then what they do is they write to me if the allegation is against me and ask me to please present my work, saying that this is the allegation which is coming. So please submit your work, which is submitted in confidence. Jamshed has already submitted his work, and then this goes to a panel of experts anonymously, incognito. That means they don't know whose script this is, so there is absolutely no conflict of interest. They examine the two, and if there is indeed a substantial, strong similarity, then in which case the investigation moves further to try and figure out how is it that this person stole that person's work. Now, the thing here is that there is no statutory power that we have. Obviously, it's a trade union. So the trade union at best can be a mediation committee. But because it has a certain credibility, because we are objective about it, we're not merely because I am a member and Jamshed may or may not be a member, that doesn't naturally give me any advantage over Jamshed at all. Because we judge it very independently, objectively, and whatever is the truth, whatever is just and fair is eventually declared. If they have to move against me and take disciplinary action, they would do so. If they have to inform Jamshed that I'm sorry, I think your allegation is mistaken, there is indeed not enough similarity to say that he's stolen your work. There's only a generic similarity. So this rigorous process is gone through, and then there is a decision which is declared. Now, I might be the kind of person who might say, no, I don't care what you have declared. I don't care what you have decided. I will fight this. In which case, if I refuse to cooperate with Jamshed and own up that the authorship is his, Jamshed is entitled to go to court. Now, here, as Jamshed points out, the decision of the Dispute Settlement Committee becomes important for the High Court, because we go through a whole process sequentially of very rigorous investigation in this. So that entire dossier is submitted with the complaint to the High Court. They go through that and use that to take their investigation or take their examination of the case further, and a certain judgment is declared, which of course is binding because the court has enforcement authority, which the union doesn't. But what we would like is if most of the complaints, most of these disputes are handled internally, which means within the film industry, which is with the Screenwriters Association, because they're the writers, they're meant to be the experts on judging scripts. Then in which case, the writer, complainant like Jamshed doesn't have to spend lakhs of rupees going to court. Court is expensive. Now, I'll go one step further, Lohita, and just mention that since many producers who may be in the wrong refuse to cooperate, what we have done is set up a legal aid fund. So for members who are not able to afford court fees, we subsidize out in favor of whatever is fair. So it might serve as a deterrent for others to go ahead and copy, whether it's the writer is copying or the producer is copying.
Right. Anjum, the general practice in this industry works on understandings between people. How would you suggest young writers ensure that they enter into an agreement which protects their rights? And in fact, Jamshed can add to this, this question is something that Jamshed can also contribute to legally.
Yeah. First and foremost, I would say, nothing should go on an oral agreement here. What you're doing is you're creating intellectual property. It is your bread and butter. It is the future of your career. And once the film is released and the royalties begin to kick in, maybe for the next 100 years, you and your heirs will begin to earn royalties on because of that work. As a result of which, do not trust any oral agreement is my advice to writers. So therefore, it is important that you first sign an agreement. Now, for the agreement to be signed, usually the company, production company, has a lawyer. They draft it. Fair enough. That draft comes to the writer. The writer should not agree to anything unless you show it to a lawyer. SWA has a full-time legal officer precisely for this, so that they can examine those contracts and be able to point out to the writer what is fair, what is not fair, what is working in his favor, and what is unfairly against it, so that he can go and negotiate. It's only after that negotiation is over that an agreement is signed. Once it is signed, where your rights are protected, that is when you begin work. Before that, absolutely there should be no pen to paper at all. Because generally, Lohita, the practice has become is, okay, yes, the agreement will take place. Yet it is take place. Here you take some money and you start working. The writer being in need and believes that that is the norm and the producer is giving me this opportunity. So he accepts that token signing amount and begins to work. And then when the agreement comes, it's completely lopsided. But by then you've already submitted a draft or two because the agreement has taken long. So this practice has to be stopped. Once the agreement is done, then and only then you are legally protected under that, whatever be that. So this is the thing which I would say. Don't work without an agreement. And number two, don't sign without showing it to a lawyer.
Right. When it comes to a plot where probably you have a co-writer, how important is it to have a formal agreement with regard to the ownership of the IP? And how do you really determine? Because sometimes you may have a co-author just to kind of execute, probably you don't have the time. So like, what are the different kinds of relationships and how do you handle this situation from an agreement point of view?
See,
a junior writer, senior writer, from that.
Sure. First and foremost, to answer your last phrase first, there should be absolutely no advantage or no prerogative and no leverage, excess leverage, that a senior writer should have on account of his seniority with a junior writer. It doesn't matter. What is authorship? Authorship is your contribution to the final product. So if there is to be a shooting script, if this is the norm of SWA, that if more than 33% of the shooting script is the work of a person, then that person gets co-writing credit, whether he's the junior most and the other person might be the senior most. So to qualify for a co-writing credit, 33% or more of the shooting script ought to be your work. Number two, if more than 50% of the shooting script is your work, you get top billing. Even if the person opposite might be a veteran of 28 or 40 years, it doesn't make a difference. Number three, when you engage a co-writer, it depends on which stage you're doing it. If you've already written down the story, if I've written out a story, I've registered the story. So the authorship and ownership of the story at that stage is established as mine. Fair enough. Now I want a co-writer to help me write the screenplay of that. In the screenplay, we are supposed to be working jointly. What should be the dynamics of this relationship? That he writes a draft and then I write a draft based on that. So there is actual documented, written out drafts which clearly, where the contribution of both people can be individually identified in case there is a dispute. And between the two of us, therefore, the ownership of the screenplay is shared. The authorship is shared. So the screenplay has to be registered in both people's names. You can decide on the order later, depending, as I said, on whose work is more in the shooting script. This has to be maintained. Now, if I'm the senior person and I'm the one who's going to be negotiating with the producer, there has to be an understanding, if need be via email, where the other writer says that this should be my minimum fee. If he is not going to be there for negotiation, ideally he should also be there. The two of you can work out an arrangement by saying that, okay, I think I would like to charge this much. This person says I'm bringing in this much. It's transparent, fine. So I go there, I negotiate for that, wherein the check issued for his share is in his name. It's not routed through me, that you pay me and I will now pay you. No, you are writing as an independent writer in this team for this particular production house, then you will be paid by the production house. I will be paid by the production house. This degree of transparency, Lohita, between two writers is absolutely imperative. Because I will tell you something which is rather painful. Given the tradition of this film industry, senior writers have been known to take advantage of junior writers. In extreme cases, the new writer is doing most of the work, what you called execution. Execution is actually realizing the vision of the story in the form of a screenplay, which is actual writing. That is creative work. Okay. So they do that, and I take away all the credit because I'm a senior person. I'm the one who engaged you. I don't give you credit. I get all the money of which a pittance is paid to this person. And this practice has to be stopped with immediate effect. And we have been discouraging this. So we have been encouraging writers, new writers, to come to SW with complaint, regardless of how senior your partner, so-called, may be. Even if that person is a member of the Screenwriters Association and of the Dispute Settlement Committee, it doesn't matter. We will move against them because this practice has to be stopped. So, Lohita, fairness is about the contribution of your efforts to the film. That is what is fair. Nothing else counts here.
So, Jamshed, Anjum mentioned earlier that from a Screenwriters Association point of view, they consider 33% contribution. He also said that in most cases, the co-author can say that I want independent means of remuneration, where probably if it's me and Anjum, I can negotiate directly with you if you're the producer. And the third thing he also mentioned is, yes, there should be a very clear understanding. Now, from a court of law point of view, how will this be considered, especially a weightage given by Screenwriters Association? And secondly, in your view, should there be a formal agreement between the two co-authors, irrespective of the contract with the producer? Or sometimes a co-author may not have a contract with the producer because Anjum may say, fine, I have, you're working with me.
So let's start from first principles. The first thing is, yes, there has to be a contract between the writer and the producer, because that is necessary not only from the writer's perspective, but even more importantly from the producer's perspective. Because when he goes out to, for financing of his film, etc., he needs to show that he's got all these people contractually bound. For example, if he goes to a studio, okay, they'll say, are all your contracts in place? And we've been saying right from the beginning, the writer is the cradle. So his contract and his IP rights, how have they been assigned, or have they been bought over, or has he been commissioned, whatever. So that is a very important document. And sometimes I feel, unfortunately, not much time is spent, even as far as lawyers are concerned, on the writer's agreement. So I think that's now. What does a writer's agreement, which are the clauses importantly that you need to? Yes, definitely the monetary aspect. Yes, definitely the credit. But I think also in today's day and age, I think it's very important to bring in the aspect of the alternate dispute resolution. And as Anjum said, that the Screenwriters Association is acts as a mediation process. I think mediation should be compulsory, and perhaps internationally the use of of arbitration, so that you keep it within the industry, and you do it in a manner that is globally accepted. And I think arbitration today, with the online process, it can happen very, very quickly, and it can be even far less expensive than actually going to court, because an arbitrator can be an expert in the field, or there can be a panel of three, and that way at least you ensure that it doesn't become sort of a public spectacle in court as it sometimes becomes in matters like this. Especially if somebody goes to court last minute, and the whole question of oh, the producers invested so much money, and therefore but because there's no doubt that the writer's right as the first author is absolutely paramount. The second thing is the contracts between co-authors, and I think that is a very good point, because you in the process, if there is a co-author, and in fact, this is something that the Screenwriters Association should pay a lot of attention to, because a lot of disputes have happened where a producer has, for example, hired another author to look into a script that was, obtained from, say, author X. And and then, both the authors say, hey, listen, we don't have a problem with each other, but this is the producer that has, created this issue. Ultimately the matter is settled. But before it is settled, such a lot of sleepless nights and such a lot of money has been spent by all parties, which is, quite, unnecessary in my respectful submission. But I think, so yes, it is very important that a similar contract clearly assigning and clearly stating that the rights that a co-author has, the original author, who is it been assigned to, and where is it finally going to go to? Because that is also important. I mean, if the producer wants to then, further assign these rights to studios, etc., they need to mention that even in a prima facie mode in a contract. The other thing, please remember that a contract can always be amended. That's something that people forget. It's not that it's once it's signed, it's absolutely cast in stone. You could have amendments depending upon the circumstances that happen. So I think this is and yes, technicalities of a screenwriter's contract. I think it should be simple. It should explain exactly what both parties' intentions are while entering the contract. Also, timelines, etc., should be very clearly stated. And then finally, in case of a dispute, etc., you must have a compulsory mediation segment or a clause which usually takes care of a lot of things. And then, of course, if you can't, then either arbitration, or then finally the court of law, which is
Right. Right. Jamshid, from a writer's point of view, what are the rights that they can enjoy when they are writing an original piece, and when they're probably commissioned to write for an existing piece? But of course, they will write on an existing piece to give it a new outcome, and obviously that will be a completely different piece altogether in most cases.
could you just repeat the question?
So my question was, what are the rights that a writer should keep in mind when he is writing an original piece? I mean, what are the rights that he should keep in mind? Secondly, what are the rights when he is writing for a piece which is already in existence? So possibly you're writing for a web series, or you're writing for a sequel of a movie. But of course, what you will write will have a completely different story, right? Because it may be in the same theme or genre, but it will be completely different. And of course, Anjum, your views as well on this.
So the fundamental difference is that in the where he is the first author, or it is his own script or his own writing, and then he has gone to the producer and handed it over, and then that is developed into a script. So his rights as the first owner or the author of the as a copy under the Copyrights Act, that remains with him. Okay, so he in essence assigns the right to the producer. That's really what happens. But his fundamental right as first owner or author will always remain, and that's really the difference in the act, that or the amendment that has taken place. So he will always remain. You can't take away that from him, and that remains, as you know, for is valid at least for 60 years after his death. So that's how long it is valid for. So that's the difference. So legally he's very strong. As far as it is a commission work, then you are, I mean, like I mean, the parallel is like an employer-employee relationship, where it's a work for hire, and then those clauses come into play. Yes, of course, uh, his rights will be there, but they will not be, you know, if I may use the word, so, strong as the first owner or the author, because you are then taking somebody's adapted version and or assigned version, and then taking it further. So your rights will be there, but it will be less protected in that sense. Yes, protected certainly, but to a lesser extent. And these things become very important, of course, when it comes to other issues like royalties.
Anjum, do you see any challenges faced by writers in cases where they're probably just, commissioned to do work on existing pieces?
Yeah, see, let's define also Loita existing piece. Many times it's an idea that the producer has, and he calls me and says, okay, this is what I would like you to work on. It's just an idea or a concept, whatever it is. But the fact is that he's the one who's initiating it. So as Jamshed said, that he's commissioning me to write it. In which case, whatever it is that I write, my authorship is clear of that, and no one can take that away. And by law, it is guaranteed to me. But whatever it is that I submit. But the ownership of that work, right from the word go, belongs to the producer because it's commissioned work. So it's like, in other words, he's hiring my services as a writer. Now, here what happens is that the challenge is that as the work proceeds, according to the contract, and the payments are rolling in, if at some stage there is a creative difference, then in which case the ownership at all times will remain with the producer. So if the producer cites creative differences at some stage and says, okay, thank you very much, I don't want you to write it, I have no hold on that work. That work belongs to him. All I can lay a claim to is the authorship in case, as I said, my work constitutes more than 33% of the thing. If it constitutes less than that, I don't even get credit on that. Whereas if it was an assignment of rights, there is, because meaning in the cases where I have written the entire script and I go to the producer saying, this is my work, and do you want to make it? He says, yeah, I like this, I would like to make it. Why don't you assign to me the right to make it? In which case I have a hell of a lot of bargaining leverage, to the extent that if the producer is really desperate for that work, I might even limit the assignment by saying that I'm giving the right to you to make a Hindi film out of it. And that's it. Every other right remains with me. If tomorrow morning another producer wants to make it in Telugu, I will negotiate with him independently. Tomorrow morning somebody wants to convert it into a web series, I retain the right to give that. Of course, this is depending on how much leverage you have. If the producer is so desperate, he said, no, even just the right to make a Hindi film is good enough for me because I'm going to make a Bahubali out of that. In which case, by all means, we can do that. So there's a hell of a lot of leverage that I have as the independent original author and first owner of that work.
What about adaptations from books? And this is a question for both of you all. Probably we didn't discuss it earlier, but I'm very curious to know, say if there's a book, it's an original book, but a writer is making an adaptation, possibly he's just inspired from that book. Then what are the rights that come into play? How should one go about it?
Jamshed, if you don't mind, let me go in first here, please.
Yeah, please.
See, a book is a literary expression. The format is that of a novel of literature, correct? Now, authorship rights of the book and although other royalties that the person may be getting is I have nothing to do with that. But if I want to adapt it, then in which case, number one, I need to ask him for the right to adapt it. In which case, there is going to be a transaction and an agreement between him and me, whereas I have to put down that you are assigning the right to me to adapt this film into adapt this book into a Hindi film or into whatever else that I might want
What
to
if
do.
it's just inspired? You're not exactly adapting it, it's just inspired.
The point here is that if you're inspired, then there cannot be any case against you of copyright infringement, because if you're taking any amount from it which will constitute infringement or plagiarism, in which case you are in trouble, then it's not inspired.
Right.
Inspired is a very loose term that people use. In the film industry, for the longest period of time, when they used to steal work from Hollywood and from French films and from South Indian films, they would say, oh, we were inspired by that. So it's a much abused term. There has to be a legal precision here. So if I have to go to him to ask for rights, that means it's not inspired. Because inspired could be that he's written some fantastic story of Romeo and Juliet where a rich boy falls in love with a poor girl and all kinds of hell breaks loose. Fine. I can work out rich boy, poor girl and set it in my own setting and work that out, which is very different from that. Conceptually, there is a similarity, but there are 28,000 films on this concept itself. That is inspired. That is inspired. Or a person fighting, say, a tornado and saving his entire community. Now that might inspire me. My God, it was so good, it was so heroic. Just take that inspiration, which is a general inspiration, it's a generic thing. Then there is no need for me to ask for rights. But if I'm adapting it, and Lohita, there is no rule for adaptation. If I get the rights for adaptation, there is no obligation on me that I have to take the story comprehensively or that I have to take a certain percentage of the story. I don't have to do that. I can take a character, I can take a subplot and turn that into my main plot as has frequently happened. But the thing here is I need to take those rights from him, in which case there has to be an agreement and most likely there will be a payment. Now, sometimes there's a two-stage thing. I say, okay, listen, I don't know whether I can sell it. So I'm optioning it from you, which means I am booking it. So for the next 1 year, I have optioned it with this token amount that I give you. But in that option agreement, it is very clear that after 1 year, that option agreement will lapse and the rights will go back to him unless I extend it. Number two, that if I'm able to get a producer in this next 12 months, then once the producer thing kicks in, so he's going to put it down that I need this much fees. After you do all this at that stage, if you tell me, okay, boss, I'm giving you, 25 rupees that the producer is giving for this, in which case he's not interested. He said, why did I wait for 1 year? I could have sold it elsewhere. I could have sort of assigned my rights for a more lucrative amount. So all those basic clauses have to come into the option agreement that I make with the original author of that book. Based on that, now I have the right to freely go and use my 1 year to see how best I can adapt it into a screenplay, giving it a cinematic form. In that duration, he is not allowed to go and show it to anyone or allow anyone else to take those rights because it is reserved by me. Like in India, we do कि भैया बस में ST बस में चढ़ने से पहले you throw in your handkerchief from the window, saying wherever the handkerchief is like, that's my seat. This is what we do. We throw the handkerchief in there. So then, now, is there, if your question is going to lead up to, do I have creative liberty to interpret the story in my own way? I'm afraid yes. Because by and large, unless the author is like some celebrated big superstar novelist, and very few of them have that leverage, where he can determine, okay, no, I will have the right of approval, that you have to show me the script for me to approve, okay, yes, this is not distorting my work. Otherwise, there is a paragraph in most agreements, adaptation agreements, which says that you will have no right to interfere. I can do exactly what I want with this. Because I need that freedom. I cannot have the author like a bogey on my shoulder telling me, no, you can't do this, you can't do that. That's not how I saw it. You don't even understand cinema. You don't even understand screenplay structure. So leave it to me. So this freedom, creative freedom, has to be taken as long as the other legal and professional obligations are down on paper and then they are fulfilled. This is how it goes.
Right. Your views, Jamshed?
So, in addition to what he said, there is another aspect, and why it has become so important, even from the producer's perspective, and especially if in the case of an optional agreement, what happens is that studio these days, and especially in matters that have gone to court, they say that okay, if it is an adaptation, please show us the original agreement that you have entered into with the original author, and only on that basis will be sign with you, because there have been instances where things have gone to court and the original author has come and said, I'm sorry, but person who's taken the rights, for adaptation, there has been no agreement with us, and hence, injunction and so many other problems. So this has now become a norm. In the sense, it is as per the act, but it has now become a custom and usage, and perhaps rightly so. So this is followed. Let's be very clear. Not only in India, it is a global phenomenon. That's the other good thing about entertainment and law. This is a so irrespective of if you want to adapt, yes, creatively, as Anjum very beautifully put, I must say, you have the freedom to do whatever you want. And let me tell you that the courts have actually appreciated that aspect of the writer's, creativity, that he can, that once something is given to him, then what he does and how he creatively evolves it into, the final product and that's what he's there for. That is what he's being paid for, and that's what he then becomes famous for. So the courts have appreciated that aspect, and quite often in such cases the court even refuses to interfere in case as Anjum rightly said, if the first author says, no, you have to show me the script, you have to show me what you're doing, etc. Nothing doing. You handed it over to him. It's his baby. As long as he has paid you for it, and as long as you have that document, and then you've taken the document ahead with the producer. That's where we are today.
Anjum, you've been one of the most. Yes, Anjum, you want to say something?
No, it's just that I have a meeting coming up at some stage soon. So I wanted to ask you if are we going? Do we need more time?
Sure. I'll just end it with one last question.
Please.
Right. Could you tell us something about the Screenwriters Association and the various initiatives to help writers?
Certainly, with pleasure. See, the Screenwriters Association is a body which was registered sometime in 1960, okay, as a trade union by various stalwarts. I mean, Ravanand Sagar, Madhu Sultanpuri, and Kishan Chandar, and it was meant to be for what it's doing now, which is to protect writers, to ensure that there is that the position of writers in the film industry is protected, and etc. Unfortunately, things didn't quite remain that way, and very soon it became I'm sorry, but near defunct body. I mean, it was there, but it was just there in name. So over the last, since 2008, I mean, there is this whole group called the Progressive Writers Group. They came in, took charge, won the elections, and from then to now, they've been steering this union. So they've been in the executive committee. Now, there is a two-pronged approach that we have taken since then for the last 13 years in the Screenwriters Association. Number one is the union aspect, which is that to fight for the rights of the members, which is the writers. So therefore, we have a legal officer who looks at contracts. We also, the lobbying for the Copyright Act amendment took place, collective bargaining, another initiative and a push is coming up just now. So these are the union actions which we are pushing for. On the other hand, knowing that screenwriting as a subject has not been taken very seriously in India as a well-defined task, where there is not sufficient education about the reasons, which I do not want to go into. But we did realize that perhaps one of the other ways, or one of the second way of empowering the writer is to ensure that she ups her craft, she does good work, because that is what will increase the demand, that is what will increase the position of the writer, and as a result of which bargaining power increases, because then your work is wanted. So it's important to up that and not feel, okay, the director will dictate and I will work that out. So trying to create an independent grip and caliber of the craft of screenwriting. So therefore, for that, there are several initiatives that we put in motion, like workshops, education workshops, training workshops. Then there are conferences where screenwriting is debated, which is all India conferences. There have been fellowships where actually we have paid fellowships to help people up their craft with mentoring. There have been script contests There have also been script labs. We've collaborated with various other institutions like Asia Society, with Sundance and Mumbai Mantra, and various other universities, colleges, etc., to ensure that we use those platforms to impart education to new as well as aspiring writers. So these two prongs continue to happen simultaneously. Apart from that, there is the dispute resolution committee, which we spoke about, which mediates in disputes. Okay, whether it's the dispute is to do with breach of contract or whether it's to do with copyright infringement. Over and above that, we also have a legal aid fund, as I told you. So we also extend support, financial support, to writers who perhaps might need to go to court, provided they have been through the dispute settlement committee process. And at the end of it, the opposite party has not agreed to the decision or refused to abide by it, in spite of there being overwhelming evidence, in which case we encourage our members to go to court. So these are some of the initiatives that we have been undertaking.
So this has been a great discussion, and I'm sure young writers or anybody who are looking to write will learn a lot from this session. Thank you so much, Anjum Jamshed, for your time, and we hope to keep in touch.
Thank you very much, Lohita. You were very, very encouraging, and your questions were very lucid, and they actually stimulated us to reveal whatever it is.
Thank you, Anjum. Thank you.
We'll copy that.
Sure.
Yes.
Bye.
Thank you. Thank you.
Bye.